once again for joining us in the fourth installment of our webinar series in terms of your FIC Act compliance obligations. Particularly what we'll be looking at in part 4 of our webinar is targeted financial sanctions, screening of employees, that's in terms of Directive 8 of 2023, and also reporting obligations. So to get us underway, we're joined by Michele, which we all met in our first part of the series. But Michele, just to kick us off, how does UNSC resolutions find application in South Africa's legal framework? And what do we mean when we say that client information must be scrutinized? That word against targeted financial sanction lists. Please, can you enlighten us? Thanks, Michele.
Thank you, Mo, and welcome back, viewers. I hope you are still very excited and very entertained. This is a very important segment of this webinar series where we deal with targeted financial sanctions. Now, there are the specific obligations in the FIC Act. There's other legislation that applies, and significantly to help you with this, I have to, from the start, highlight that the FIC has published very prominent and useful guidance to help you understand your obligations. These are very critical obligations. So, Mo, to get back to your first question, maybe, South Africa's application of the United Nations Security Council resolutions and the Financial Action Task Force recommendations 6 and 7. These are reflected in our FIC Act, specifically sections 26 capital A to 26 capital C, read with 28 capital A, where the scrutinizing obligation, in fact, is provided for. Then there's also sections 4, 15, and 23 of the Protection of Constitutional Democracy Against Terrorism and Related Activities Act. Much better or easier to refer to it as POCPATARA. And this then collectively sets out the targeted financial sanction obligations for our viewers and all other persons in South Africa. You'll see that it then applies not just to accountable institutions, but to all other persons as well. Importantly, section 26B, read with section 49A of the FIC Act, clearly provides for a prohibition. It prohibits the financing of persons or entities who are subject to targeted financial sanctions in terms of section 21A of the FIC Act. The prohibitions that relate to the TFS regimes are absolute, and they must be applied by all persons in respect of designated persons or entities. No person may, in whole or in part, enter into or facilitate a transaction for persons or entities listed on the UNSC resolution. So we are clear, this is an absolute prohibition. The prohibition is applicable but not limited in all instances where the designated person or entity is in fact a client of the accountable institution, or a person acting on behalf of a client, or a client acting on behalf of another person, or the beneficial owner of the client, or a party to a client's transaction, including a party who benefits in any way from a client's transaction. And then, Mo, you asked, what does scrutinizing mean? So when we specifically look at section 28A(3) of the FIC Act, there's a requirement for our crypto asset service providers. They must scrutinize information concerning clients with whom they have a business relationship against the TFS list. It's a must. And that is to determine if such persons are designated persons or entities or linked to designated persons or entities. What this really means is there's no walk back. If this scrutinizing did not take place and that business relationship is entered into, or that single transaction is actually concluded, where the customer is designated, then the deal is done. So there's no scenario where our crypto asset service providers will not be scrutinizing the information concerning a client when they establish a business relationship. They must scrutinize the information against the targeted financial sanction list, regardless of any unique factors they might perceive, such as the client being a South African national or the transaction is not cross-border. I want to reiterate, there's no circumstances where this scrutiny must not take place, even where the level of risk is perceived to be low. So the screening must be applied for both domestic and international transactions. Now, the screening is one part. You screen or scrutinize for the purpose of getting a result, to see if there's in fact a confirmed positive match. So the results from scrutinizing the client must then be used as a factor that informs the risk rating. It's fair to say that a positive match informs an immediate high risk rating, and we have to think of that prohibition once again. And secondly, it attracts a freezing and a reporting obligation. And these are two very significant obligations, again, that has to be provided for in the RMCP. And there are very specific timeframes in which to do this. So overarchingly, Mo, we know how the requirements find application. We know what scrutinizing means. What information should our viewers then use when they do scrutinize the clients? And importantly, when should they scrutinize their clients?
Thanks, Michele. And yes, I think very important questions. Importantly, what our accountable institutions should be on the lookout for is when scrutinizing, you need to scrutinize the person's name, identification number, place of birth, address, date of birth, nationality, the entity's name, and or other information. You may include other information when scrutinizing, but it's not limited to the country of residence in the case of a natural person. Accountable institutions must scrutinize the information concerning a client at onboarding, when conducting transactions, and when the TFS list is updated. And I think these are key times that an accountable institution should take note of when to scrutinize. Accountable institutions must scrutinize information concerning a client against the TFS list without delay, and that means within 24 hours of the list being updated. The reason for this is that when a UNSC resolution is adopted, designating persons or entities, that resolution has immediate effect in South Africa for purposes of application of Sections 26B, Section 26C, and 28A of the FIC Act. The process adopted for purposes of scrutinizing client information against the TFS list can be done manually or through an automated system. And for this, we refer you to PCC 44A on the FIC website, as well as Guidance Note 6A. Some of the observations that we've made in terms of targeted financial sanction screening is, firstly, failure to scrutinize clients against the TFS list. As you know, you are not allowed to do business with anyone that is on that list. So failure to scrutinize or to even consider any of your clients against that list is a violation. Secondly, failure to maintain records of scrutinizing clients. And this is important because sometimes we see entities indicating that we have screened against the TFS list. However, they are unable to provide evidence of that screening. That's why it's important that you maintain records or evidence the fact that you have scrutinized against the TFS list. This evidencing should be done in terms of having a record of the date of the fact that you've screened your client against the list, indicating times, date stamps for us to be able to understand and to note when you have scrutinized the clients against the TFS list. This also applies to false positives that you may get when scrutinizing against the list. So that's important to note. Michele, using the TFS list does not only find application in respect of clients, but also the employees of a CASP. Could you tell us a bit more about this obligation?
Yes, Mo. The FIC issued Directive 8 of 2023, which importantly should be read also with Public Compliance Communication 55. Now, what Directive 8 actually says, it directs accountable institutions, our viewers, to screen prospective and current employees in a risk-based manner for competence and integrity. That's the one part. The second leg, as it links into the topic we just discussed, they also have to scrutinize employee information against the TFS lists. And that, of course, is in order to identify, assess, monitor, mitigate, and manage the risks of MLTFPF. So the adequate screening of the competence side and the scrutinizing on the TFS list of your employees' information, that will allow you as the viewer to ensure high standards when you hire your employees. And similar to understanding the risks that relate to your customers, you need to appreciate the fact that such risks can also arise in your business internally through your relationship with your employees. So you, the viewer, must provide for, and you need to record the manner in which screening for competence and integrity, as well as the manner in which scrutinizing of your employee information against targeted financial sanction lists will be conducted. It requires a documented process that you implement. So you have to then obviously also keep record of the results following your screening and scrutinizing. Accountable institutions must then also apply, as we've mentioned many times, the golden thread, the risk-based approach, when determining the level of risk an employee role poses. So it really means you have to sit back and assess what the roles require of certain persons in your business and to what extent that screening and scrutinizing is going to take place. Based then on the outcome of the screening of a prospective and current employees, you must take a risk-based decision to ensure the risk is mitigated and managed. And again, you know, if there's question marks of how to do this, we refer you back to both the directive and the PCC to help you with that. So screening for competence, that in essence refers to how you determine whether the employee has the necessary skills, the knowledge, the expertise to actually fulfill their function, do their job. And remember that integrity relates to honesty and moral principles of the employee. And this could include determining whether the employee doesn't have a criminal record, particularly if it relates to crimes of dishonesty, money laundering, or other financial crimes. Must occur on an ongoing basis. I think ongoing is a word we're also getting used to now, Mo. And then the scrutinizing against the TFS list should be done before the appointment. Again, remember, you can't walk that decision back. If we look at some of the findings, because we assessed this during our inspections, it does seem in some instances that there's failure to assess the competence of employees. So that's the one part. So their expertise, their honesty, things like that. And then secondly, the other important leg, to scrutinize employees against targeted financial sanction list. This could be because maybe institutions are not fully aware of this obligation, or it has not been properly provided for in the RMCP, but you are now made aware. If you have not done so yet, please, this is an obligation. So Mo, we've discussed different topics so far in our installments, and the word reporting keeps coming up. there's clearly very specific reporting obligations. Before we go into the detail, it might be useful for our viewers to get a high-level sense of their reporting obligations, which I invite you to share with them.
Thank you, Michele. So yeah, I think reporting is key, and we've touched on this. It's a critical obligation within the FIC Act. But importantly, your process to identify, assess, and file reportable transactions must be contained in your risk management and compliance program. So I think that's critically important for all entities to take note of. Secondly, have note of the money laundering and terrorist financing control regulations, because this provides details of what should be considered when filing a report with the FIC. There's two important requirements in relation to filing reports with the FIC. Firstly, filing quality reports, which requires an accountable institution to provide all the relevant information comprehensively in the report. Merely stating that a transaction activity is suspicious without providing context would certainly not be helpful. Secondly, filing reports to the FIC as soon as possible. Old intelligence is not good intelligence or workable intelligence, as they say. The FIC places great reliance on reports filed by accountable institutions. Kindly note the difference or the differentiation between reportable transactions and reportable activities, as well as the wide range of reports to be filed by accountable institutions with the FIC. Note further the dual reporting obligations, which mean do not fall foul of complying with reporting obligations due to the misnomer that the bank must or will file the report. And I think we've seen this quite a bit, Michele. Keep records of your assessment and decision to file or not to file reports with the FIC. And also, you must be registered with the FIC under the correct schedule item number to be able to file reports. Those are of utmost importance in terms of reporting. So let's look at the AML CFT value chain. On the left of your screen, you'll see our little diagram or circular diagram. And on the top, you'll see that what we consider first is the South African understanding of its money laundering, terror financing, and proliferation financing risks. And this is understood or done through the national risk assessment, but also the sectoral risk assessment. At this point, I'd implore you to please go to the FIC website and have a look at the national risk assessment, and for crypto asset service providers, the sectoral risk assessment that have been published on the website. That then filters through to accountable institutions, and Michele has spoken about your business risk assessments and then formulating your risk management and compliance programs. So you, as the accountable institution, now understand the FIC Act obligations in respect to money laundering, terror financing, and proliferation financing risks, specifically what those risks are. And you are then now in charge of mitigating through your CDD, through your compliance obligations, and through filing reports with the FIC based on your risk understanding of your clients. That then culminates into reports that are filed with the FIC, and this is enhanced with further information, and a complete report is then issued to law enforcement agencies. The law enforcement agencies then analyze this information or consider this information for an initiation of an investigation based on that information that was received, lastly culminating in criminals being prosecuted, convicted, and their assets confiscated. So I hope our viewers can observe or note the importance of their role in the criminal value chain and the AML CFT value chain, more importantly. On the right-hand side of your screen, you'll see another block diagram, and this indicates the supervisor's role in terms of ensuring that this value chain is upheld. So importantly, it's to prevent criminals from entering the financial sector, also to ensure that there's a conducting of supervision on a risk-based approach to ensure that our accountable institutions comply with the FIC Act. Also, our role as supervisor to enforce non-compliance if there are any with the FIC Act. And then lastly, to create awareness on FIC Act obligations, money laundering, TF, and proliferation financing risks. So how does a life cycle of a statutory report look? So obviously this will start from a risk or a trigger that has been identified by the accountable institution or through the national risk assessments that have been provided, or the sectoral risk assessments. And based on that, through your RMCP, you would then file a report. The institution in turn has internal processes for this reporting, and this will culminate in a STR, SAR, TFTR, or TFAR that then is filed on the web-based system that we've alluded to earlier called GoAML. This is then captured by the Financial Intelligence Center, and through the Financial Intelligence Center's internal processes, they will then analyze this information and generate two types of reports. One report is called a referral, where the FIC initiates a referral report to the relevant law enforcement agencies for them to consider the contraventions or possible criminal activity in terms of money laundering, terror financing, or proliferation financing. The second type of report is called a request. This request usually stems from a law enforcement agency which requests for information from the FIC regarding a particular investigation that's ongoing. The FIC will then provide this information together with any suspicious reports that have been provided to the relevant law enforcement agency for them to consolidate and investigate. As you can see, there's a number of institutions that this information is provided to, mainly any investigative division in an organ of state, other FIUs, supervisory bodies, the SIU, NPA, in our intelligence services, defense intelligence, the public protector, law enforcement agencies, the South African Revenue Service, as well as IPID. So that's just a demonstration of the life cycle of a statutory report. So, Michele, with the benefit of the high-level background on reporting obligations, let's delve deeper into specific types of reports. Could we start with cash threshold reporting?
Yes, I think the high-level background was very necessary and useful. Thank you, Mo. Like you mentioned, there's different kinds of reports. There's a range, and then there's also the distinction between activities and transactions. So perhaps let's start with the most well-known one, cash threshold reporting. This is dealt with in Section 28 of the FIC Act. Accountable, it's applicable to our accountable institutions, our viewers, and this relates to a report that's filed to the Financial Intelligence Center on cash that's paid by the accountable institution to a client or received by an accountable institution from a client. It goes both ways. It's important to note what cash means. Cash means cash. It does not include electronic fund transfers, interbank transfers, and the like. How would you know that there was cash received or cash paid? Check your bank statements and do it frequently, especially if your bank details are in the public domain, albeit that you, in terms of your business model, don't necessarily deal with cash. If your bank details are in the public domain, this can certainly pose a risk. So check your bank statements. Note that there has been amendment to the threshold. It's now 49,999. Like you said, Mo, throughout the discussion on reporting obligations, the regulations will feature strongly. So viewers, please take note of that, because the regulations really sets out what information you have to report in terms of a particular report. This also speaks to the quality mentioned by you, Mo, to provide all the information that's required. So go look at the regulations, read it with your reporting obligation in the primary law to make sure you know all the information that you should provide. The GoAML system was developed in line with the regulations, so That's the only place you can report in any case. What we want to, I think, importantly emphasize, you put it so eloquently, Mo. Yes, there are certain periods for reporting that is provided for in the legislation, but the golden rule is report as soon as possible. In the case of a cash threshold, report not later than 3 days after becoming aware, but certainly the sooner the better. It is possible in some instances that the nature of what you find when there is a reason to file a cash threshold report, the circumstances might also require from you to file a suspicious transaction report. It's not so in all cases, but be aware that you might have additional reporting requirements. Guidance Note 5C also provides a detailed explanation and guidance in this requirement. So familiarize yourself with that. Now, with regards to the CTRs, and I think we will touch on this just so, again, there is room for introspection. What are the kind of things, not necessarily a supervisor will come and ask me, but what should I be asking myself? Then it would be easy to answer whoever is asking the question. We are going to look at whether you have reported all your CTRs and whether you've successfully reported it. It is so that sometimes a report is filed on the GoAML system, but because it was all the mandatory fields maybe wasn't completed, or there's some issue with what you have captured, then the report is rejected and you are notified to remediate the filing of that report. You need to do that because a rejected report is the same as a report that's not filed. So file it properly the first time. If there is a reason for rejection, please, without delay, go and remediate. Then, of course, whether it has been reported timeously, important. So how are we going to look at it? The same as what you should be looking at. As we mentioned, bank statements. We're going to look at the bank statements, your bank statements, same as you look at it, to see if there's any reportable transaction. We're going to look at client files. So, for example, if you say you are not a cash-intensive business, but there's all these cash payments and slippies in the client files, then there's going to be a contradiction. So make sure that your business model and whether you allow cash or not, also the publication of bank details, how that is reflected come the review of client files. And then compare what is claimed by you and what's been reported by the FIC. So we do, in fact, engage the Financial Intelligence Center before we conduct inspections, specifically to see if there has been transactions or activities that has been reported by you as the accountable institution. So make sure that they match the information that we independently use to see your reporting profile or behavior, that matches what you actually share with us during inspection. And again, it's not just for purposes of inspection. This is also for you to understand your customer base better. What you report on, how frequent you report, how many times you file different reports in terms of a specific client, is going to tell you more about that particular client. And yes, as mentioned, that remediation, it is critical. I will say it again, a report that was filed but rejected and not remediated does not count as a filed report. Right. Basically, Mo, that sums up the cash threshold reports. Now, we have talked about targeted financial sanctions. We said that there's the scrutinizing requirement. If there's a positive match, there's a freezing obligation, there's a reporting obligation. There's a lot to be said about this. So for this slot, I'm going to hand it over to you to explain this to our viewers in terms of these specific reporting obligations. Thanks, Mo.
Thanks, Michele. And yeah, definitely, I think coming from us understanding our TFS obligations in terms of screening or scrutinizing against the targeted financial sanctions list, we note there's various types of reports that we have, but specifically what's applicable to targeted financial sanction screening and the report that has to be made there is Section 28A. So accountable institution must submit a report in terms of Section 28A of the FIC Act if it has property owned or controlled by or on behalf of or at the direction of any entity which has committed or attempted to commit or facilitated the commission of a specified offence as defined in Pacta, or a person or entity identified pursuant to a resolution of the Security Council of the United Nations, contemplated in a notice referred to in Section 26A, Sub 1. The Director of the FIC may direct an accountable institution who made a report in terms of Section 28A to make additional reports. An AI must, upon notice being given by the Director under Section 26A, Sub 3, scrutinize its information concerning clients with whom it has business relationships in order to determine if it has a client listed in the proclamation. So what is the period of reporting? And here, as soon as possible, but not later than 5 days after the AI has established that it has property of a client appearing on the UN sanctions list. The FIC may approve late reporting of a TPR in certain circumstances. And in terms of Regulation 22A, it provides for the information that needs to be reported on GOML with respect to Section 28A. The knowledge about the origin and ownership of the property in question is based on fact and should be acquired with reference to an objective set of circumstances or facts, as opposed to a suspicion that is merely formed subjectively. Lastly, guidance has been issued by the FIC in terms of Guidance Note 6A with respect to this type of reporting. So what is property? Money or any other movable, immovable, corporeal or incorporeal thing, and includes any rights, privileges, claims and securities and any interest therein and all proceeds thereof. And this is defined in terms of Section 1 of POCA. So quite a broad definition of property. Property is also defined in Pacta to mean money, movable and immovable property, corporeal or incorporeal thing, and most importantly for our purposes, crypto assets. If the AI has a client as specified in Section 28A Sub 1, but it does not hold or control property of that client, there will be no reporting obligation on the AI in terms of Section 28A. The AI, however, may have to report a suspicious or unusual activity report under Section 29 of the FIC Act. What are some of the specified offences as defined in Pacta? And there are quite a few. But it's important to note that the client must have been convicted of an offence or the attempted commission of an offence specified in Pacta. Some of these offences defined in the Act include terrorist activities, financing of specified offences, explosives or other lethal devices, hijacking, hostages, causing harm to internationally protected persons, hijacking of an aircraft or a ship, harboring or concealment of persons committing specified offences, duty to report presence of persons suspected of intending to commit or having committed an offence, hoaxes, threats, attempts, conspiracy to commit offences specified in Pacta. So quite a wide array of offences specified in the Act. In terms of Section 26A of the FIC Act, this alludes to the TFS list of the FIC Act, refers to natural persons or entities identified by the United Nations that are involved in terrorist acts and or are connected to the proliferation of weapons of mass destruction. Firstly, in terms of Sub 1, a resolution adopted by the Security Council of the United Nations when acting under Chapter 7 of the Charter of the United Nations, providing for financial sanctions which entail the identification of persons or entities against whom member states in the United Nations must take the action specified in the resolution has immediate effect, and that's key, for the purposes of this Act upon its adoption by the Security Council of the United Nations. Hence, we alluded to the fact that reporting needs to be done, or screening needs to be done without delay. 1A, a resolution contemplated in sub 1 ceases to be in effect upon a decision of the Security Council of the United Nations to no longer apply that resolution. In terms of sub 3, the Director must, by appropriate means of publication, give notice of the adoption of a resolution by the Security Council of the United Nations, as contemplated in subsection 1, persons and entities being identified from time to time by the Security Council of the United Nations pursuant to a resolution contemplated in subsection 1, a decision of the Security Council of the United Nations to no longer apply a resolution contemplated in subsection 1A to previously identified persons or entities, and lastly, a decision of the Security Council of the UN to no longer apply a resolution contemplated in subsection 1A. Screening occurs against the United Nations Security Council 1267 list. Here, the President has issued a government gazette under Section 25 of Paktatara on the 14th of July 2017. The government gazette refers to this resolution, and the list can be found at the link that we'll be providing in the slides. There's also a link on the FIC website which you're able to access this list. The 1267 list contains names of members of Al-Qaeda, the Taliban, and ISIL as well. In terms of Section 26A sub 1, this refers to resolutions by the Security Council of the UN other than Resolution 1267. Targeted financial sanctions refer to restrictions on activities that relate to particular countries, goods and services, or persons and entities. Targeted financial sanctions measures generally restrict sanctions persons and entities from having access to funds and property under their control and from receiving financial services in relation to such funds and property. In order for these sanctions to be given effect, the FIC Act requires AIs to freeze property and transactions pursuant to financial sanctions imposed in the UN Security Council resolutions. Section 26B requires AIs to freeze assets of clients named in the lists Section 26B requires AIs to freeze assets of clients named in the lists referred to in Section 26A. Should an employee of an AI become aware that the AI is not adhering to Section 26B, it must report it as a STR under Section 29(1)(b)(6). No person may enter into any transaction or establish a business relationship with persons or entities identified on the TFS list. On the TFS list, the Minister of Finance has published the list of resolutions adopted by the UN Security Council to which the FIC Act applies. There's currently 14 ongoing United Nations Security Sanctions regimes which focus on supporting political settlement of conflicts, nuclear non-proliferation, and counter-terrorism. The current sanctions regimes include the Central African Republic, the Democratic People's Republic of Korea, Democratic Republic of Congo, Guinea-Bissau, Iran, Iraq, Lebanon, Libya, Mali, Somalia, and Eritrea, South Sudan, Sudan, and Yemen. So, Michele, we have made reference to suspicious transaction reporting on several occasions during this webinar series. Could you assist us in understanding what are suspicious and unusual transactions?
I'm going to do my best. I know that this is really a mouthful, these reporting obligations, but that is why it's important that we spend enough time to making sure our viewers have a clear understanding of the obligations. So when we talk about a suspicious transaction reporting obligation. It is Section 29 of the FIC Act that really applies. It is, again, an obligation on any business, and that includes accountable institutions, so it includes our viewers. And it's then reportable by the owner of the business, a person who manages the business, or who is employed by a business, who then knows or ought to reasonably have known or then suspects, that being the operative key word, that the business has or it's about to receive proceeds of crime or terror financing related property. Knows or ought reasonably to have known or suspects that a transaction or a series of transactions for that matter to which the business is a party to facilitated or likely to facilitate the transfer of proceeds of crime or TF-related property, has no apparent business or lawful purpose, and is conducted for the purpose of avoiding giving rise to the reporting duty. Important. It might be related to tax evasion, financing of terrorists, and relates to a contravention of what you have talked about extensively now, Mo, on the freezing obligation. So the business has been used or is about to be used for a money laundering or terror financing activity. Going back and to refresh the memory of our viewers, we talked about Section 21 capital E when we discussed customer due diligence obligations. And just to reiterate that obligation spoke to reporting. So the Act states that an accountable institution must consider submitting a Section 29 report to the FIC should they be unable to establish and verify the identity of the client or other relevant persons in terms of the RMCP, or obtain information about the business relationship with the client in terms of the RMCP, and conduct ongoing due diligence, as you have extensively dealt with, Mo. And like you've said, there are a big range and types of reports. We should distinguish between transactions and activities, but also just make it clear that when we deal with Section 29 type reports, it is based on suspicion. And suspicion, in its ordinary meaning, is a state of conjecture or surmise where proof is lacking. So where there's doubt or question about the truthfulness. I suspect it, but I can't prove it. Right. That is, however, not the end of Section 29. In terms of 29.1, an institution must report to the FIC the grounds for the knowledge or suspicion and particulars of the transaction or series of transactions. And that is proactive. I think you also mentioned that in the high-level introduction, Mo. It's not good enough just also to say that something looks suspicious. No one can interpret what that means, and then the intelligence does not have value. In terms of Section 29, so if the AI receives inquiries about transactions or series of transactions, and the institution knows or suspects that these transactions may be suspicious or unusual, it must report the grounds or knowledge of that suspicion and particulars to the FIC. A report must be made not later than 15 days, but the golden rule, as we are really trying to repeat, is as soon as possible. With regards to STRs, suspicious transaction reports, there is no threshold. So unlike the threshold in a CTR, a cash threshold report, there is no set threshold. It can be R1 or R1 billion or a gazillion. What information has to be reported? Again, we're going to look at the the regulations. As we said, those are very important in terms of what is required to file this particular report. And you know by now that the place you will file it is GoAML. It is the FIC's internet-based portal, and you need to be registered to file the report. So we want to also share with you that no person who made a report or suspects that a report has been made may disclose that fact or information regarding that report, but there are a few, so you may not. The exceptions are for purposes of an inspection that's conducted by, for example, the FSCA as a supervisory body, or if it is within the scope of the powers and duties of that person in terms of whatever legislation, for the purpose of carrying out the provisions of the FIC Act itself, for purposes of legal proceedings, or in terms of a court order. Now, just to bring this together and to help you not to be confused. So there's some differences between your Section 28A and your Section 29 reports. So let's go through them slowly so it can remove all doubts that you might have. In terms of the Section 29 report, there it is we refer to a suspicion. So you don't know it for a fact, it's a suspicion. But the 28A report is filed based on information that is factual. There's no guesswork. In terms of Section 29, the Act applies to any person, so the application is very broad, whereas 28A applies only to accountable institutions, you, the viewer. A report made in terms of Section 29, if made in the prescribed manner, is a valid defense to charges brought in terms of Section 4 of Boktatara, which deals with offences associated or connected with the financing of specified offences, and Mo, you dealt with the specified offences. In many instances, why it's useful also to see the differences between the reports is it may be that you file multiple reports, and it could be under both Section 28A and 29 for the same client. So when you file a report with the FIC in terms of 28A, it is an offence to continue dealing with that property in any way. Whereas opposed to filing a report in Section 29, you may in fact elect to continue with the transaction as provided for in Section 33 of the FIC Act. So these highlight some of the differences, but I hope that then clarifies it a bit more. Very important to note that Section 29 refers to reports being made in connection with suspicions concerning proceeds of unlawful activities and MLTF and financial sanctions offences. So we want to just highlight that the FIC Act does not require reports to be made on suspected crimes or unlawful conduct by a person. Similarly, the FIC Act also then provides that a reporter may continue with and carry out a transaction in respect of which a report is required to be made unless the FIC directs the reporter not to proceed. Again, keep those communication lines open, make sure the contact persons on your profile on GoAML are up to date, and attend to any engagements when the FIC reaches out to you. You may not want to miss a directive in this regard. Then the FIC may request additional information that is important. So once you file the Section 29 report, essentially, and you may have done a very good job when the FIC, through its internal processes, analyzed the intelligence, they might come back to you and ask for more information. Please be of assistance there and provide a quick response. The FIC Act essentially then also provides protection to persons who participate in submitting reports to the FIC. So there's no legal action, criminal or civil, that can be instituted against a natural or legal person who complied in good faith with their reporting obligations. The Act protects the identities of those people who filed the reports. They can't be forced to give evidence in court. They can volunteer to and opt to do so, however, if they so choose. And then importantly, in terms of Section 69 of the FIC Act, if a person who is an employee, a director, or a trustee, or a partner of a crypto asset service provider, if such a person is charged with failure to report an STR, That person could raise as a defense that they complied with the RMCP, that escalated the matter to whoever in the business was supposed to report. This links back to what we highlighted, Mo, in terms of prevalent inspection observations on RMCPs, and we deliberately said that sometimes from a technical deficiency perspective, the processes to identify reports, to file reports are not very well articulated and documented. So it clearly comes into play in terms of this defense. Unlike most other compliance obligations, very important here, the failure to submit a report to the FIC is a criminal offense. It's not just a non-compliance. It's a criminal offense, and it can also attract an administrative sanction. So wrapping up on suspicious transaction reporting, as much as record keeping is the other side of the coin to CDD, this is a very important requirement when it comes to reporting obligations as well. Records must be kept from at least 5 years from date on which the report was submitted. Keep records of your decisions not to file a report to the FIC, and reminding you just once again that you have to look at the regulations to make sure that you know what kind of information to file. Just before we completely close off on suspicious transaction reporting, Mo, there is clearly a lot of use and value in looking at the regulations, looking at guidance. From an international standard, is there an FATF view or help or tips and tricks that our viewers can consider when they might come across instances of that could lead to them filing an STR?
Yes, no, thanks, Michele. And I think that's quite an important point for our accountable institutions to take into account, especially when considering reporting or building the risk management and compliance programs, specifically in respect of suspicious reporting. But the FATF has published a virtual asset red flag indicators of money laundering and terror financing that may lead to STR reporting. And here, there's specific factors that they look at as reasons for reporting. So specifically within the CASP sector. Here, they look at technological features that increase anonymity, such as your mixers and your tumblers. I think this, to the CASP industry, would be well known, especially when transferring virtual assets. You see the use of mixers, the pseudo-anonymity that comes with having a crypto asset account or utilizing the blockchain. So I think this is something that our CASP sector should really take cognizance of. Secondly is geographical risks. And here what we're talking about, Michele, and I think it's an important point that FATF has raised, is looking at which countries are you susceptible to? Where is virtual assets being transferred to? Where is your clientele from? And looking at whether those countries have regulations in place. Are they also complying with FATF? Obviously, we've got grey listed countries, we've got blacklisted countries, and we've got countries where transferring any sort of property is prohibited. So it's important for our institutions to take that into account in terms of geographical risks. Then looking at transaction patterns. And I know our CASP industry uses various tools to assist them in identifying patterns of their transactions and mapping that transactions. So it's key here for our CASP industry to look at whether the transaction is being structured, whether there's small amounts being utilized on the blockchain for various reasons that may look suspicious, but also, clients that come into the crypto asset service provider solely to conduct one transaction and then off board or leave the institution. So it's important for us to look at what sort of patterns are we noticing that may assist in reporting suspicious transactions. Then we look at transaction size. Like we say, the amount that's being transferred. Obviously, in terms of a crypto asset service provider, you would have an idea in terms of your client. We all know the price that one Bitcoin is currently sitting at. So looking at the values in the respective jurisdictions, looking at what's being sent and for what purpose is critical for reporting here. And then also looking at sender or recipient profiles and looking at the source of funds or wealth. I think looking at crypto assets specifically, obviously there needs to be some place where you can onboard your client and transfer their fiat currency into crypto assets for that to be used. It's important for you to have an understanding of where did the client get those funds in order to convert into crypto assets for you to then transfer. So I think those are some of the important things that we need to look at when it comes to suspicious transaction reporting.
That's very useful, Mo. Then, now that we've wrapped up on STRs and given some tips and tricks, we mentioned that communication with the FIC is a two-way street. Institutions file reports, FIC file requests for additional information. Can you share with the viewers obligations in terms of Section 27 reporting, and then also touch on Directive 3A as it speaks to reporting failures? Thanks.
Yes, no, certainly, Michele. So I think importantly, in terms of Section 27, I think a few of our AIs would have some experience in receiving a Section 27 request from the FIC, but this is a tool that the FIC uses. And what the Section 27 requests is it requests the crypto asset service provider whether a specified person is or has been a client of the AI, whether a specified person is acting or has acted on behalf of any client of the AI, whether a client of the AI is acting or has acted for a specified person, whether a number specified by the FIC was allocated by the AI with whom the AI has or has had a business relationship. But I just want to pause here, Michele, just on the number that's specified. So now obviously we know we've got, in terms of the crypto asset industry, we've got wallet addresses. And I think this is quite an important thing because the FIC would usually send a 27 request with a particular wallet address for you as a CASP to identify it or to assist in identifying. Then also they will request on the type and status of a business relationship with a client of the AI. The FIC Act does not state a time period within which a Section 27 report has to be submitted to the FIC. However, the request from the FIC will definitely contain a period within which the AI has to respond to. An AI that fails to submit a Section 27 report can be criminally charged or receive an administrative sanction in terms of the FIC Act. Then, in terms of Directive 3A, where a person or institution becomes aware of a reporting failure to the FIC, such person or institution has to mitigate the loss of intelligence data to the FIC in the following manner. Firstly, inform the FIC in writing of the reporting failure immediately after becoming aware of such failure. The notification must be sent to the Executive Manager, Compliance and Prevention, Financial Intelligence Center, and request an engagement with the FIC to discuss relevant mitigating factors. The subsequent arrangements for the mitigation of loss of intelligence due to the FIC does not imply condonation of the failure to report information to the FIC, nor does it absolve the reporter from its continuing reporting obligations under the FIC Act or prevent enforcement action being taken by the relevant supervisory body. Here, we refer you to Guidance Note 4B, Guidance Note 5C, and Directive 3A, all available on the FIC website. Thank you, Michele.
Thank you, Mo. Yes, a parting gift, a parting slide to high-level summarize a very thorough discussion of reporting obligations. There's different sections in the FIC Act that deals with some different kinds of reporting obligations. There's the money laundering control reporting regulations that helps to know what kind of information to file, the types of reports, and then the reporting periods, all in one place with reference to the necessary guidance. Moses brings us to the end of part 4 and close to the start of part 5, which will be our concluding part. We thank the viewers for staying with us, reminding you that you can watch these webinars as often as you like until you feel you get the hang of what the understanding should be, that what your takeaway should be. We hope you find this useful, and then we will see you for part 5, where we are going to look at what you should be very interested in as crypto asset service providers, and that is the travel rule. We will see you soon.